Assalamualaikum warahmatullahi wabarakatuh. So, we are from the second group of International Treaty Law. We would like to present our discussion about depositories, notification, correction, and registration of a treaty. I am the first speaker. My name is Auria Rahmani, and my friend is Rahel Maulana as the second speaker. First of all, I would like to explain what is a depository. Depository means a person whom something is entrusted, but depository also means a government or an organization to which a multilateral treaty is entrusted. A bilateral treaty is usually signed in a duplicate of each of the contracting states keeps one signed original. In the most exceptional case of a bilateral treaty having only one original text, the contracting states would have to decide which of them should keep it, or alternatively take hold deposit it with a third state or an international organization. Designation of depository. In Article 76, Number 1, the designation of a depository may be made by the negotiating states either in the treaty or in some other manner. The depository may be one state or very occasionally two or more, an international organization or its chief administration officer. Also, there will be a word of warning when a state is a depository. Its duties should be carried out only by the foreign ministry. Depository functions sure the same whatever the subject matter of the treaty, and the necessary expressive is found only in a foreign ministry or an international organization, since they have detailed experience of treaties and the proper procedures. An international organization as depository. Most multilateral treaties are not adopted within an international organization or an international conference convened by one. But there are some exceptions. The treaty will designate as depository the chief administrative officer of this organization, or its Secretary General is willing to be the depository of all multilateral treaties. The duty to act impartially. Multilateral treaties cause problems which requires action by depository. A depository state must at all times keep a very clear distinction between its views and national interest as a state and its function as depository. Also, the function of the depository. The function of the depository have been listed in Article 77, Number 1. The first one is keeping custody of the original text of the treaty and any full powers. Second one is preparing certified copies of the original text. The third one is receiving any signature and authors. Fourth, examining whether the signature or any instrument, notification, or any communication relative to the treaty. The fifth, to inform the parties. This is based by Article 78. The sixth one is informing the states. And lastly, following entry into force. This is based on Article 80. Notification and communication. Except a treaty or a present convention otherwise provide any notification or communication to be made by any state under the present convention. So, the first one, if there is no depository, be transmitted direct to the state for which is intended, or if there is a depository to the latter. The second one is to be considered as having been made by the state in question only upon it received by the depository. And lastly, if transmit to a depository, be considered as deciphered by the state for which it was intended only when the latter state has been informed by the depository in accordance with Article 77, paragraph number 1, section E.
And next I will explain about the correction of errors in a treaty. It is common for errors to occur in the text of treaty because the lack of time to check the text before adoption or signature. In many cases, there's just a type of graphical spelling, punctuation, numbering, or cross-reference errors. This type of errors can be easily replaced or corrected because this type of errors does not change the substance of the treaty. But correcting anything which is more than an obvious physical error or a mistake of spelling or numbering may affect the substance. Punctuation is an aspect of grammar which is perhaps more crucial for some languages, including English, than others which have more certain grammatical rules. In Article 79, it explained that the procedure for correcting errors is set out in detail. In paragraph 1 deals with the case where the treaty has no depository, such as bilateral or a few multilateral treaties. If the error is only typographical and the treaty has not yet been published, the one method is for one foreign ministry to send the other under cover of a third person diplomatic note a photocopy of the original text with the correction inserted clearly by hand. Once the correction has been agreed, an authorized official of each side can then insert them in the original held by it. But if the error is more than typographical or the treaty has been published, the most prudent course is for the agreed correction to be set out in an exchange of notes. Since the note will be recording only corrections, not amendments, the exchange should not be expressed to constitute an agreement. And then the paragraph 2 deals with the case where there is a depository. Whether he has been alerted to the error or discovered it himself, the depository must initiate the correction procedure by notifying the signatory states and contracting states of the error and the proposed correction. In practice, the UN Secretary General will communicate proposed correction to all states which participated in the elaboration of the treaty, even though only the signatory and contracting state have the right to object to a correction. If there is no objection, an authorized official of the depository makes the correction of the text of the deposited treaty, initialing each correction. The depository then draws up a process verbal recording this and circulate it for information to the signatory and contracting states. If after the authentication of a text, the signatory and contracting states are agreed that it contains an error, it can be corrected by initialing the corrected treaty text, by executing or exchanging an instrument containing the correction, or by executing the corrected text of the whole treaty by the same procedure as in the case of the original text. If there is a depository, the depository must communicate the proposed correction to all signatory and contracting states. In the UN practice, the Secretary General, in his function as depository, informs all parties to a treaty of the errors and the proposal to correct it. If on the expiry of an appropriate time limit, no objection arise by the signatory and contracting state, the depository circulates a process verbal of rectification and causes their correction to be effected in the authentic text. If no objection has been raised, the depository shall make an initial correction in the text and shall execute a process verbal of the rectification of the text and communicate a copy of it to the parties and to the states entitled to become parties to the treaty. And if an objection has been raised, the depository shall communicate the objection to the signatory states and to the contracting state. Next one is registration and publication. Under Article 102 of the United Nations Charter, every treaty and every international agreement entered into by any member of the United Nations must be registered as soon as possible with the Secretariat and published by it. Treaties or agreements that are not registered cannot be invoked before any organ of the United Nations. Registration promotes transparency and the availability of text of treaties to the public. In Article 80 of the Vienna Convention also requires the parties to register any treaty to which it is a party once it's in force. Registration, regulation, and procedure. The main rules are: 1. A treaty is not registered until it has entered into force for at least 2 parties. And then the second one is registration may be done by any party and relieves all other parties of the obligation to register. The third one is the United Nations must register ex officio every treaty which authorizes the United Nations to register it or which designates the United Nations as the depository or which the United Nations one more UN members are parties. And then all subsequent actions affecting changes in a treaty, such as amendment or termination, must be registered. And then a treaty which has already been terminated may still be registered. And then the date of receipt of the treaty by Secretariat for registration or the date of entry into force in the case of registration ex officio is deemed to be the date of registration. To register a treaty, one must submit certain documents to the treaty section of the Office of Legal Affairs of the United Nations. The first one is a copy of the treaty, and then the additional copy, and then if it's not sent by email, either 2 additional paper copies or 1 hard copies, an electronic copy on diskette or CD. And then if the treaty is not in English or French, a courtesy translation into one or both languages should be supplied in the same form with the same number of copies. And then the text of any reservation or declaration. And then if it's not clear from the text, that the title of the treaty, the names of those who sign, or the date and place of signature should be specified separately. And then the last one, the date on which the treaty entered into force for each party and the method by which this was done. Thank you for your attention. That's all from our presentation. If you have any question, you can send it to the WA group of International Treaty Law. Wassalamualaikum warahmatullahi wabarakatuh.